There are very many very skilled and very dedicated legal aid lawyers in this country who do a very good job. Of that there is no doubt. What is also beyond doubt that the cuts that the government have put into legal aid over the last 5 or 6 years have gone very deep indeed, and many of the most skilled and experienced criminal barristers in England and Wales no longer accept legal aid cases at all, or accept far fewer of them. Now, paying for representation doesn't automatically guarantee good representation either. You're going to have to be very careful when selecting a lawyer to make sure that they are properly versed in the documents that you've sent them, that they read them properly, they allocate the right time and resources to your case, and have a track record in what you're asking them to do. In other words, going and delivering a case to a jury. That can be very difficult to do. The best thing to do usually is to look at reputation, previous cases, the type of cases that barristers are instructed in, because the marketplace overall tends to pick the best barristers for the biggest cases. Recent changes in the law have allowed members of the public to instruct counsel directly, in other words not going through a solicitor, which historically a member of the public would have to do before having access to advice from counsel. What I'm able to do now is to offer my services and my advice to people when they come to me directly. One of the main benefits of direct access to me is the ability to put together a team to defend somebody when charged with a crime. I now have the ability to choose and to advise what solicitor to use. They may need specialist skills, may need specialist knowledge, and I'm able to choose a solicitor that fits the case and that case alone. I'm also, if necessary, I'm in a position to be able to choose junior counsel, again, who may have specialist knowledge or skills for that particular case. And that of course also involves experts. There are many forms of experts, and expert evidence is often very relevant in sexual offences. I know from my experience which experts are the best ones to call in front of a jury. Often experts can appear to be very similar as between each other on paper. They're all very well qualified and they may give a written opinion that very much accords with the next person's opinion, and there doesn't seem to be a lot to choose between them. But by definition they are going to give evidence which is complicated and outside the knowledge of the jury, and being able to deliver that expert evidence which is technical by nature to a jury is very important. And I have seen most of the experts in this country giving evidence in courts before, and obviously have knowledge of which ones do and which ones don't give good evidence in front of a jury, explain themselves clearly, explain their opinions in, for example, a non-arrogant way that is jury friendly, and that can be very important too. Direct access for the first time in this country has really allowed the advocate, which would be me, to put the team together in advance of the trial, so I can focus all of our resources and all of our energies on the right parts of the case, and there leads therefore to no wastage in the case, having a solicitor instructed who doesn't really have much to do, or junior counsel instructed that doesn't have much to do, or experts that have not been focused or hand-picked. So direct access for me, I think, is a real plus, especially in the field of sexual offence cases, because often you don't need all of those disciplines to be involved. Whereas in the past, having to go through a solicitor meant that by definition you'd have a solicitor, you'd have counsel, and then maybe junior counsel, when on some occasions you wouldn't need them, or if you did need them, you may have the wrong people in the team, and that is no longer the case, which is a massive step forward as far as I'm concerned.